Good morning, everybody. It's my pleasure to welcome you here on behalf of the British Institute of International and Comparative Law. My name is Yarik Kryvoi. I am the Senior Research Fellow in International Economic Law and Director of the Investment Treaty Forum. This is the first Africa Arbitration Day which we organize, and we hope that it will be a regular annual event where we will discuss Africa-related dispute resolution, arbitration in the first place. And BIICL is pleased to organize this event jointly with Queen Mary University of London, as well as Babcock University. The program is split into two half days. So we have a half day today, half day tomorrow, which makes a full African Arbitration Day. Just a few words about the British Institute of International and Comparative Law for those who are not based in the UK and may not know much about it. The Institute is one of the leading independent research centers for international and comparative law. We conduct research projects, we organize seminars, conferences, publications on almost all areas of public and private international law, comparative law, and European law. We also organize various trainings for government officials, for lawyers, and in general, we are very happy to discuss possible ideas and projects, not only related to dispute resolution, but more generally to law, comparative law related to Africa. So as I mentioned, this is the first conference, but we will organize this conference annually. And this conference reflects the growing interest and the growing importance of Africa in the world's economy, and in the area of international dispute resolution. So we put together four excellent panels, very diverse panels with speakers coming from Africa, Europe, North America. These are experts on dispute resolution related to the African region, and we have private practitioners, we have scholars, we have government officials. Hopefully, this will allow us to have a very interesting and constructive discussion today and tomorrow. We would like to thank our sponsors, Freshfields, Brookhouse Deringer, and Linklaters for supporting this conference. These two firms do a significant amount of work related to African arbitration, and we'll have speakers from these firms later today. So the plan is to cover four panels today. We'll have a panel devoted to inclusiveness of arbitrators. Then we'll have a panel dealing with investor-state dispute resolution and the challenges related to investor-state dispute resolution. Tomorrow we'll have two panels as well, one dealing with Africa as a seat of arbitration and local court support, and the other panel will be about African courts and enforcement of arbitral awards. In addition to these four panels, we are blessed to have two excellent keynote speakers. Tomorrow, we will hear from Honourable Mr. Mike Chibita, who is Justice of the Supreme Court of Uganda in Kampala. And today, our keynote speaker is the Honourable Minister Abubakar Malami, who is Minister of Justice and Attorney General of the Federation of Nigeria. Mr. Abubakar Malami was born in 1967, and he is a Nigerian lawyer and a politician. Since 2015, he serves as Minister of Justice and Attorney General. And when he was appointed, he was the youngest minister in the cabinet. He studied at the College of Arts and Arabic Studies, then attended the College of Legal and Islamic Studies, and then he was admitted to study law at the Usmanu Dan Fodio University. And after that, he had a career as a politician, as a lawyer, and we are very pleased to have him with us today. The minister will speak for about 30 minutes, and then he kindly agreed to answer questions. The way how we ask questions is by typing your question in the Q&A box. You will see at the bottom of your screen a Q&A box. And you can ask your question, and those and others who are taking part in this conference will be able to upvote this question. And this way, if there will be many questions, we'll be able to focus on those questions which are particularly interesting for our audience. That's enough from me. And now I would like to welcome Honourable Minister Malami to address the participants of the inaugural African Arbitration Day. And as I understand, the Minister is going to speak about arbitration laws and practice in Nigeria, and he will also make a few comparative remarks about other African jurisdictions. The Minister, if you could unmute yourself, the floor is yours.
Thank you very much, Prof. And let me seize this opportunity to welcome all the participants to this African Arbitration Day. The perspective from which I intend to talk is exclusively on the arbitration and conciliation as it relates to the Nigerian jurisdiction. Perhaps with some references where the need arises to some other jurisdiction where I find it relevant to bring about some level of comparisons. For the purpose of arbitration and conciliation, the applicable law as far as Nigeria is concerned is Arbitration and Conciliation Act 1988, incorporated in the laws of the Federation of Nigeria as Chapter A, 18, Laws of the Federation of Nigeria, 2004. So this is a national law governing the arbitration in Nigeria. Arising from the provision of Arbitration and Conciliation Act 1988, the basic legal requirements of an arbitration are the following. 1, agreement must naturally be in writing. 2, agreement must be contained in written document and signed by the parties. 3, agreement must be consensual. And by way of associated components, the agreement, arbitral agreement usually contains place or seat of arbitration, validity clause, number of arbitrators, method or procedure of appointment of the arbitrators, and perhaps where the parties deems it necessary qualification or expertise of the arbitrators. Now, the courts in Nigeria are often inclined to uphold the provisions of Section 4 and 5 of the ACA, which provided the necessary conditions are met. What are the necessary conditions as far as the Nigerian legal system is concerned are indeed contained in the ACA Act and indeed had some judicial pronouncements relating thereto. For example, in the case of MV Lupex versus NOC, reported in 2003, 15 Nigerian Weekly Law Report, FAT 844 at page 69, the Supreme Court, which is the apex court of Nigeria, held that it was an abuse of court process for the respondents to institute a fresh suit in Nigeria against the appellant in the same dispute during the pendency of arbitration proceedings in London. So what I'm trying to state in essence is that the courts in Nigeria are often inclined to uphold the provisions of Section 4 of the ACA, and which sections establish conditions in the case of Minaj to the effect that the claimant instituted a court action in breach of arbitration agreement in the main contract and on the defendant's application. So once parties are in agreement with particular reference to recourse to arbitration, the court in Nigeria is very reluctant in allowing the parties to approach judicial proceedings, but the court is always ready and willing to allow for the stay of proceedings and allow for the consummation of arbitral processes between the parties. And in so doing, and in that respect, attempts by parties to arbitration to have recourse to court were adjudged abuse of court process, except of course if the parties mutually and consensually submit to the jurisdiction of the court by way of taking steps without raising the issue relating to arbitration. So the court, in essence, grants stay of proceedings of the judicial proceedings, provided there exists in the parties' agreement arbitration clause that sanction referral to arbitration as a first condition before any further recourse to judicial proceeding. Again, Section 48 of the ACA provides elaborate grounds for setting aside an award. So an award, arbitral award, could be set aside, but then the court is always reluctant in setting aside arbitral award, and provided the statutes, that is ACA Act in Nigeria, provide exceptional and limited circumstances under which arbitral award could now be set aside. Again, under Section 29 and 30, the grounds for setting aside an award are merely stated as decisions beyond the scope of the submission to arbitration. Misconduct of the arbitral tribunal and improper procurement of arbitral proceedings are some of the grounds that could now allow for setting aside. Similarly, Section 52 provides elaborate grounds for refusing the recognition or enforcement of an award, whereas the grounds for the refusal of recognition are not stated in other provisions of ACA. So now coming to the issue of the law governing international arbitration based on ancestral model law, is there a significant difference between the two? Between the Nigerian law and the ancestral law, the major striking difference is that of stay of proceedings. The ACA, which is the Nigerian law applicable, has accommodated the possibility of stay of proceedings, but the ancestral model law does not expressly confer on the court the power to stay proceedings commenced in breach of an arbitration clause. So that are the striking differences between the Nigerian law as far as arbitration is concerned and ancestral law, which is the component relating to the stay of proceedings. But then generally speaking, the major similarities between the two has to do with the fact that both laws recognizes consensus of the parties, autonomy and possibility of variation depending on the wishes or perhaps express agreement of the parties. The law is there, no doubt about it, but the rights of the parties to bring certain, to come to certain understanding in as it relates to the displacement of the applicable law is tolerated. That indeed is what the position, that indeed is a position established by our judicial processes that allows for the continuation of judicial proceedings, notwithstanding the consent of the parties to concede to an arrangement that, notwithstanding the consent of the parties to arbitral clause in an arbitration agreement, provided they submit themselves to the jurisdiction of the court and take steps relating to judicial proceedings without timeously raising the issue that borders on the referral for arbitration as a condition precedent. So generally speaking, ACA, which is a law applicable in Nigeria, does not stipulate any particular subject matter that may not be referred to arbitration. But by judicial processes and proceedings, the scope of which matters could be referred to arbitral disputes has been established through judicial process and mostly and substantially restricted to commercial arbitration. For example, Section 57 of Section 1 of the ACA provides that arbitration in defining what a subject matter could be tolerated as an arbitral matter is stated that arbitration means commercial arbitration. So in essence, the scope of subjects that could be considered for arbitration is restricted by the interpretation section of the law to commercial arbitration. But in a case reported, a Kano State Urban Development Board versus Funds Construction Limited, reported in 1990, 6 Supreme Court 103, the Supreme Court of Nigeria recognized categories of matters that are not arbitrable in Nigeria. They include indictment for an offense of a public nature, dispute arising out of an illegal contract, disputes arising under agreements void as being by way of gaming or wagering, dispute leading to a change of status such as divorce petition, and any agreement purporting to give an arbitrator the right to give judgment in rank. So these are expressly some of the exceptions established through judicial process, as it relates to those matters that are not often for arbitration by the party, notwithstanding the agreement of the parties. Again, an arbitral tribunal is permitted to rule on its own jurisdiction. So when it comes to issue of jurisdiction with particular reference to Nigerian situation where any of the party challenges the jurisdiction or the powers of the court to have the arbitral dispute determined, the court is vested with the power under Section 12 of the ACA to now look into the contentions relating to the jurisdiction and rule thereon as to whether it has the jurisdiction, the powers to determine its own jurisdiction. So the powers of the court to look into the issue of jurisdiction when raised by the parties is indeed as well tolerated by the applicable law in Nigeria. Again, the issue of an arbitration agreement, the court will always uphold the arbitration agreement and state proceedings pending arbitration where such issue is indeed raised by the parties. Now, coming to the issue of limitation of time. The statute of limitation operates in Nigeria substantially as it relates, depending on the nature of the subject in contention. The question now is whether the statute of limitation is equally applicable to arbitration proceedings. So generally, under the Nigerian law, there are limitation periods for commencement of various civil actions. For simple breach of contract, it is 6 years period. For action relating to land, it is 12 years. And for actions against public officers, it is 3 months. So the applicable law in that respect is limitation laws of the various states and indeed the laws relating to fatal accident and other public officers protection act. So the right to commence arbitral proceedings in Nigeria is not open-ended, but then is regulated by the applicable statutes of limitations, depending on the subject matter in contention, on the subject matter that is being referred for arbitration. Relating to the choice of law rules that govern the formation, validity, legality, and arbitration agreements, the position of the Nigerian law is clear. Where parties have not expressly chosen the law applicable to the arbitration, the law of arbitration will apply. So in the absence of express choice of word, choice of forum by the parties, the law of the seat of arbitration is presumed to be automatically applicable as far as due determination of arbitration is concerned. This brings me to a question as to whether can a court intervene in the selection of arbitrators? If so, how? A court can intervene in the appointment of arbitration where parties fail to agree on the procedure or methods of appointment or where the procedure agreed upon is not complied with. This is established by a judicial pronouncement in the case of Ogunwale versus Syrian Arab Republic, where the court held that by virtue of Article 8, sub 1 of the arbitration rules, when a court is requested to appoint an arbitrator pursuant to Article 6 or Article 7, the party who makes the request shall send to the request an affidavit together with a copy of the contract out of or in relation to which the dispute has arisen, and a copy of the arbitration agreement if it is not contained in the contract, and the court may require from other parties such information as it deems necessary to fulfill its functions. So the fact that the parties have not taken their time to make a choice of as it relates to the selection of arbitrators does not deprive a subject matter from being considered as far as arbitration processes and proceedings are concerned, and a party may approach the court for such appointment. So the parties are not denied an opportunity to have matter referred to arbitration, notwithstanding the fact that out of perhaps oversight or deliberate attempt, no choice of arbitrator has been incorporated as forming part of arbitration agreement. Now, coming to the procedural rules, are there laws or rules governing the procedure of arbitration in Nigeria? My answer is yes. The arbitration procedure in Nigeria is governed by the national law, the ACA, and the arbitration rules made pursuant to the ACA as well as various state laws. So the Arbitration and Conciliation Act of Nigeria had indeed provided a ground norm for the formulation of arbitral procedural directions that could now be applicable as far as the determination of arbitral proceedings are concerned. The ACA and the arbitration rules apply to all arbitral proceedings whose seat is in Nigeria, unless the parties have agreed on another choice of law. So once the choice of law is, the seat of arbitration is Nigeria by the choice of law of the parties, or perhaps by implied accommodation relating to absence of express choice of law in respect of arbitration whose seat is in Nigeria, the position of the law is clear that the that the Arbitration and Conciliation Act, and indeed the rules formulated arising therefrom, are the applicable laws, provided the seat of arbitration is Nigeria, and the parties have not, by their understanding, agreement, and consensus, made reference to particular jurisdiction for the purpose of application of the procedural process. Now, the further question relating to procedure is whether there are procedural steps that are required by law to be taken by the parties for the purpose of the arbitral proceedings. My answer, as far as the Nigerian situation is concerned, is yes, there exist procedural steps that are expected to kickstart the process of arbitration. Some of the procedural steps that are expected to be consummated include issuance of communication of notice of arbitration by the claimant. There has to be a notice of communication, there has to be a communication of notice of arbitration by the parties, which traditionally kickstart the process of consideration relating to the commencement of arbitral proceedings. And then two, the issues relating to appointment and constitution of the tribunal is equally material. So where it is indeed accommodated in the arbitral agreement, then the parties are expected to equally take advantage of the existing clauses by way of appointment of arbitrator. If it is one arbitrator, they have to come to terms for the purpose of having the arbitrator appointed. 2, 3, depending on the agreement of the parties. But then one of the major and fundamental procedural steps applicable as far as the arbitral proceeding is concerned, indeed, is the appointment and constitution of the tribunal. Again, the pre-hearing review, inspection of document or subject matter is equally a condition that is traditionally forms a procedural steps relating to the arbitral proceedings. And then the issue of hearing and the determination of preliminary issues, if any, equally comes to mind as part of the procedure relating to arbitral proceedings. Final submissions of oral or written by the parties, first hearing meeting where need for so doing arises, publication of the final award are all indeed part and parcel of the collective procedures associated with arbitral proceedings. Other issue of interest is the choice of a counsel. In Nigeria, it is a constitutional provision that parties to proceedings, arbitral and otherwise, are entitled to a choice of counsel. So within the context of that constitutional provision, and indeed the first schedule of the arbitration rules made pursuant to the ACA, with particular reference to Article 1, Rule 4, which deals with the representation and assistance of the parties, the provision of the provisions of the law relating to arbitral proceedings indeed provides in effect that the parties may be represented or assisted by legal practitioners of their choice. So the right to a choice of a legal practitioner is indeed embedded in the Arbitration and Conciliation Act, among others, and the rules that emanated therefrom are equally, have equally considered and indeed established the right of a choice of counsel. So this brings us to the next question: what powers and duties does the national law of Nigeria impose upon arbitrators? So the arbitrators that are eventually appointed for the purpose of determining the dispute between the parties are not left on their own. And then under the Arbitration and Conciliation Act of Nigeria, the arbitral tribunal has several powers, including the power to rule on its own jurisdiction, which I stated earlier, issue interim orders of preservation where there is fear of dissipation of the assets in contention or in dispute between the parties, appointment of experts where the subject matter is technical that requires input from experts for the purpose of determining the dispute between the parties, order the production of documents or evidence where the need to examine documents for the purpose of arriving at a decision one way or the other is material, and then administer oaths or take affirmations of parties and witnesses appearing before it for the purpose of establishing the credibility and confidence in the proceedings, and then on its own volition, correct in the award any errors in computation, clerical, typographical errors, or any errors of a similar nature, terminate arbitral proceedings and issue a consent award upon the settlement or agreement of the parties, determine the admissibility, relevance, materiality, and weight of any evidence placed before it, and make interim, interlocutory, or partial awards. So the arbitrators also has, the arbitrator also has had several duties under the Arbitration and Conciliation Act, some of which include a duty to give each party full and equal opportunity of presenting its case, a duty to act fairly between the parties and in accordance with the natural justice, a duty to act within the scope of its jurisdiction, a duty to decide and dispose of all issues submitted to it by the parties, and a duty to give a reasoned and valid award and to ensure that the award is enforceable. So this, in a nutshell, provides an overview of the arbitration as far as the Nigerian as far as Nigeria as a jurisdiction is concerned. And there are rules restricting the appearance of lawyers from other jurisdictions in legal matters as far as Nigeria is concerned. Fundamentally, because for the purpose of under the Legal Practitioners Act, which is applicable in Nigeria, a person who is not called to the Nigerian bar is not entitled to appear before a court in Nigeria or act as a solicitor unless on conditions stipulated in Section 2 and 7 of the Act. By virtue of Sections 2 and 7 of the Legal Practitioners Act, CAF L 11 Laws of the Federation of Nigeria 2004, a person is only entitled to practice as a barrister and a solicitor in Nigeria if he has been called to the Nigerian bar, if he is admitted by a warrant of the Chief Justice or on special circumstances, or if he is exercising the functions of the office of the Attorney General, Solicitor General, or Director, Public Prosecution, or such civil service office specified by the Attorney General. So as far as participation, appearances of foreign counsel are concerned, with particular reference to the Nigeria as a seat of arbitration, the appearance is regulated, and it is indeed a function of law, and it is not an open-ended that allows for free participation for the lawyers from other jurisdictions. I think that issue came up for determination before our apex court, before the Court of Appeal, in a case Shell Nigeria Exploration and Production Limited and 3 others by this Federal Inland Revenue Service in appeal number CA/A/208/2012, handed down by the Court of Appeal Abuja on 31st August 2016. The Court of Appeal seemed to have delved into the issue of legal representation in domestic arbitral proceedings in Nigeria. The Court of Appeal held that the notice of arbitration and statement of claim originating processes filed during the arbitration were not competent, as these were not signed by a legal practitioner enrolled to practice in Nigeria. The words of interest that I think are material for this consideration is a rider to the effect that legal practitioner enrolled to practice in Nigeria, contrary to the Legal Practitioners Act. Simply put, the Court of Appeal, in that case, took the position that representation of a party as a counsel in domestic arbitration in Nigeria amounts to legal practice, which only a lawyer enrolled to practice law in Nigeria can undertake.
Honourable Minister, if you could, one more minute to wrap up, if that's okay, because we want to have some questions.
Thank you very much. So this generally outlines the background of the arbitration proceedings as far as Nigerian situation is concerned, both as it relates to the processes, the procedure, and indeed the applicable law. Thank you most sincerely for the opportunity to be engaged.
Thank you very much, Honourable Minister, for this very interesting overview of law and practice of arbitration in Nigeria. We have not much time left. 2 questions from the audience, well, actually 3 questions from 2 speakers, and 1 question from me. In a few months ago, a very big news here in London was a decision, an arbitral decision against Nigeria, amounting to, I think, several billion US dollars, which English courts were asked to enforce. And it's a significant decision against Nigeria. And I remember that you were giving comments to Financial Times about this particular award. Would you be interested to add anything? Because already we have several months since that. But before you answer this question, let me pick up 2 more questions so that we have all the questions at once, and then you will have 10 minutes to address them. Bankole is going to ask the next question. Actually, the main person behind this conference is not me. It's Bankole, Bankole Sodipo from Babcock University, who is also affiliated with BIICL and with Queen Mary. He put a lot of effort into organizing this event and also in securing most of our speakers. Bankole, would you like to ask your question now?
Yes. Thank you, Honourable Minister and AGF. Oh, sorry. We bear the same name. Sorry.
Yeah. Honourable Minister, sir. Good morning. Thank you for a very interesting expose on Nigerian law. Sir, are there any gaps in the Nigerian law or maybe the arbitration process in Nigeria that you may have identified and which you hope to fill as part of your contribution as the Chief Legal Officer of Nigeria? Thank you, sir.
So we have 2 Bankoles today. So Bankole Sodipo already asked this question. Now, Bamikole, please, the floor is yours. Sorry about this confusion.
Okay. Thank you very much, Honourable Minister and Attorney General of the Federation. It's a privilege listening to you.
Introduce yourself as well.
Bamikole Aduloju is my name. I'm a doctoral researcher in Robert Gordon University. and my research interest is jurisprudence of justice delivery through arbitration. Now, I know there's these ties between the Nigerian legal system and English legal system, and because of the ties, you see our courts most time relying on the decisions from the English jurisdiction. But I want to know what your take is, particularly on Section 34. Section 34 of Nigerian Arbitration Conciliation Act says that the court shall not intervene in arbitration matter except as provided in the Act. But in Section 1C of the English Act, the word should is used in Section 1C. Yet, our court keep relying on the decisions from the English jurisdiction, particularly in this respect. So I want to know where your take is on this issue. Thank you.
Yeah, Honourable Minister, you have around 10 minutes to address these questions. Please unmute yourself.
Am I been heard now? Hello?
Yes, yes.
Hello?
Now it's fine.
Okay. Let me start by way of addressing the first question raised by Professor Bankole showed before. The question is, what lessons can we learn from P&ID award, and how can African states prevent such problems? I think two major fundamental and critical issues or lessons that, that one can readily learn from the P&ID award is the corruption element, due compliance with processes and procedure. The whole episode, saga associated with P&ID was indeed a product of corruption, fraud, and indeed non-compliance with processes and procedure. Take, for example, a situation whereby a company comes over to Nigeria, perhaps interested in establishing a facility, a gas plant facility, for example. The starting point is acquisition of land. A company in the circumstances of P&ID has not succeeded in acquiring the land upon which such facility is established. Associated processes and procedures that are required from the Department of Petroleum Resources, associated approvals and permits were not obtained. The agreement in its own right was not subjected to necessary processes associated with vetting by the Office of the Attorney General, associated with the Federal Executive Council approval, and yet it was signed without allowing these processes and procedures to be consummated. So the greatest lesson that is apparent arising from this is to ensure that we have in place standard operating procedures related to each and every agreement that has the potential of affecting our national economy, national interest, and ensure at the end of the day that the stated standard operating procedures are indeed followed, and ensure at the end of the day there are consequences for corrupt practices relating to the officials of government that are saddled with the responsibility of processing agreements and ensuring at the end of the day that due processes and procedures are complied with. So it is a component of tightening our situation within the context of compliances, within the context of procedure, and ensuring at the end of the day that there are consequences for wrongdoing associated with officers that are found wanting or perhaps compromising on their, compromising along the line one way or the other. The second question again is whether are there any gaps in the laws of all the arbitral processes that are identified and which we seek to fill or change? Well, I think our arbitration proceedings and processes are coming of age. We are indeed significantly making steady progress as far as the arbitral proceedings are concerned. But then one thing that I think, one gap that is visibly apparent is working towards perhaps making in Nigeria an arbitral proceeding hub, rather than perhaps maybe working towards a direction of submitting to other jurisdictions as far as the seat of arbitration is concerned, to see what we can do in terms of encouraging the choice of Nigeria as a seat of arbitration, so that what we are doing in terms of strengthening our arbitration and arbitral processes and proceedings are strengthened within the context of making Nigeria as a hub of arbitration proceedings, at least within the West African region or the African continent for that matter. A question was equally asked by BIICL Adoloju. He said, I know that because of the ties between Nigerian and English legal system, Nigerian courts do rely on English decisions to resolve disputes, including arbitration matters. I want to know what is your take on that, on the fact that despite that there is a difference between the provision of Section 34 and its counterpart provision in Section 1 of the English Arbitration Act, yet Nigerian courts still follow English decisions in this respect. I think the point of interest with particular reference to the question asked is foreign decisions are of persuasive authority as far as the Nigerian state is concerned. And I am happy to report that our literature, our jurisprudence with particular reference to arbitration had indeed to a larger extent and degree matured. And arising from that, I have copiously made substantial and sizable reference to Nigerian judicial decisions without any recourse to a foreign jurisdiction decisions in the course of my submissions. And that, in essence, establishes the point that indeed our jurisprudence as it relates to arbitration, as far as the Nigerian state is concerned, is indeed not only evolving, but had indeed substantially and sizably developed. I think that is the last question as far as I can see over the screen. And thank you for the opportunity to answer the questions.
Thank you very much, Honourable Minister. You mentioned corruption and arbitration. This is a very important topic, and I think it's becoming more and more important as more African companies do business with Western Europe and with other parts of the world. And I know that the United Nations Organization on Drugs and Crimes is now working on special guidelines, and I'm involved in this process, to address corruption and arbitration, and particularly in the context of investor-state arbitration. We are really thankful for your comments. And unless you have any final remarks which you would like to convey to the speakers who will appear later, and to the audience, then I would like to thank you for your participation and for your time. Thank you, Honourable Minister. So, okay, please unmute yourself. Then we'll be able to hear you. Could you please unmute yourself? Could you please unmute? Mm-hmm.
Yeah. Yes, thank you. My final comment, can I be heard? Am I being heard?
Yes, now
Hello?
You can be heard. Yes.
Hello?
Yes, please go ahead.
Yes, my final comment about this is to perhaps bring to the notice of the audience that indeed I'm happy being part of the African Arbitration Day. And on that note, we wish to bring to the notice and attention of the participants that we, in the Nigerian state now, we have an arbitration center in Lagos and Abuja. And I think the centers are doing wonderfully well. They are fully equipped, and the services, all the services required relating to arbitration proceedings are provided. I thank you most sincerely.
Thank you very much. So that concludes the keynote speech. I apologize that Professor Julian Lee was not able to moderate it because something has come up just before the conference, so I had to step in his role. But the moderator of the next panel is already here, Sir Bernard Reeks. I saw him already on the list of participants, who is a former English judge who was a Lord Justice of Appeal. And their panel devoted to inclusiveness of arbitrators will start at 11:10. So we would like to then now invite you to have a stretching break, as we call it. I think we have one more question. Sorry, Bankole, I think, raised one more question, or maybe it looks like open. What lessons can we learn from the and ID award, and how can African states prevent such problems in the future? So we have probably 5 minutes.
I think you answered the question.
Oh, okay. So you already answered this question.
You did.
Just looks open on my Q&A screen. Yeah. So
yes, thank you.
So we have like 15 minutes break, and then I look forward to seeing the panelists and the attendees. We have around 100 people registered for the conference, and I think they will join different points in time. And I would encourage all attendees to rename themselves to make sure that your name appears there, and also your affiliation, if possible, in brackets. For example, here I have Yarik, Kryvoi, and BIICL in brackets. So let's have a break now, and we'll reconvene at 11:10. Thank you.
Thank you.